Hi everyone, my name is Qamar Ur-Rehman. I'm a senior partner at DO Valente Solicitors and also head of immigration law. Today I will be sharing with you my recent case that was all about long residence. That may help someone who already in process of making application, might have made application and been refused, or maybe going through the appeal process. Just a little bit background of the case. Individual came from South Africa for on a student visa in 2007. In 2017, she was given a letter by the college that because of her progress in education, at the same time her attendance, they would not be able to continue her as a student, and therefore they will withdraw their CAS letter. And as a result of that, her leave will be curtailed. But luckily, then she already completed 10 years. So what we did, we basically submit an application based on her long residence in this country, legal residence for more than 10 years. One of the requirement of long residence application is that individual have to be in this country physically for 10 years legal residence, but not out of the country for more than 18 months, which is equivalent to 540 days. But in her case, it was very difficult to get those exact dates when she went out of the country or when she came back, and for the simple reason is that on passports there were too many stamps, and in some cases there's stamp on top of stamp, so it's very difficult to get the exact dates. And also when you leave the UK, there's no exact stamp. Only when you enter the country there is a entry stamp. So in some countries, I believe most of the countries, there is a exit stamp at the same time entry. And this individual was traveling to one country and from there to the other country while she was on holiday, and as a result, maybe on one trip she might have 10-12 stamps on her passport. So it was very difficult to get exact dates. And the other fact which didn't help us, that she did not keep the record of how many days she was out of the country. So we managed to get enough stamps to calculate the figure, which was slightly less than 540, and we were satisfied that we have enough information that we can make an application. We made an application, and unfortunately Home Office refused on the basis that she was out of the country for 701 days. And the information they were basing these results on is not from the stamps on our passport, and this may be news to you because that definitely was news to me, is that they received information from airlines when the individual left the country and when they came back to the country. So what happens is, if we book the ticket today and suppose I'm traveling in 1 week or 2 weeks time, airlines are duty bound to give a list of their passengers to the Home Office 20 hours before they fly. And the same way, if someone is traveling from abroad to come into UK, that airline also duty bound to give list of their passengers 24 hours before. So from that information, Home Office basically calculated 701 days that she was out of the country. Therefore, because she was out of the country for more than 540 days, she could not qualify on long residence application. What we did, we appealed that decision on the basis that we asked the Home Office, because what they did when they refused her application, they rely on this information, but they didn't give us any document to prove that. There is a not inbound outbound list provided to them by the airlines. So just simple fact stated in their refusal letter is that you were out of the country for more than 701 days, and we based this information, whatever the record provided to us by the airlines, but no copy of that record was enclosed with refusal letter. So we appealed that decision. At the same time, we asked the Home Office, please provide us that information so we can double check with our passport whether we were right to make an application at the time, or whether your reliance on that information is correct. No information was given to us. A few weeks back there was appeal hearing that was on Monday. Till Friday we didn't have any Home Office bundle. Most importantly, no information from the Home Office that this is the evidence which we are basing our refusal. But on Friday afternoon, the Home Office representative unit, the individual who would be representing the Home Office at appeal, she realized when she looked at the file that Home Office bundle was not provided to the solicitors. So she contacted us and she sent us a Home Office bundle by fax. With that bundle, the information was provided which they were relying on in their refusal letter. I mean, inbound and outbound record for our client. I was in court on Friday. My colleague, she was a little bit disheartened that now we have this information. We could have gone on a Monday to argue the case that because the information is not available where the Home Office is relying their case on, so we could rely on our information based on the stamps on the passport, and we might have a good chance of success. But since now we have this information available, therefore that may weaken our case. Baba said to her that obviously I am not able to look at that documents or bundle today, but leave it on my desk. I might come on Saturday and go through the bundle before I go for the appeal hearing. So I came on Saturday. I was looking through the Home Office information provided in their bundle. Most importantly, list of in and out for our client. What they did is they basically said that information confirms that 701 days she was out of the country, but there are few entries where there was no outbound information available but inbound was there. That means there was no record that she left the country, but few weeks later there were in country record. So what they did is, because they were confused about those figures, so they taken out those days out of their list, and what they were relying on total figure of 646. They said we have exact information about 646 days she was out of the country, so therefore she doesn't meet her requirement. Now that evidence was on the face of it looks or damaged our case, because we were claiming that she was not out of the country for more than 540 days, but Home Office information confirmed that she was out of the country at least 646 days. So I was looking through the list. What I noticed, again I will go back to the first comment I made, that she came in July 2007, and we made an application July 2017 when she completed her 10 years. Her first leave, or when she first time left the UK, was on 11th of December 2007, and according to Home Office record she came to the country 12th of April 2008. That means 121 days she was out of the country. 121 days. Now it doesn't look believable, because she left the country and on Christmas holiday, must have came back and then left again for Easter break, and that's why December and April were important dates. But because there was no entries of inbound, so therefore they relied on the information. You left the country on 11th of December, came back on 12th of April 2008. Therefore, you were out of the country in 21 days. Adding others, total was making 646. But our appeal hearing was on 9th of July 2018. So what, and this is very important for someone who is thinking of making application or who applications already been refused and they're going through the appeal process, that there is a principle that because your application was pending and then later on your appeal was pending, you are legal in this country under the 3C rule. 3C rule means if you make an application within time, you are legal in this country until the Home Office make decisions. And if you appeal that decision, you still continue with your legal leave. So what I'm explaining here is that she was legal from July 2017 to July 2018, the date when we were representing her at the appeal hearing. So I thought that if we take out, because she needed, technically now she's been here for 11 years legal. So if I take out the first year, July 2007 to July 2008, and rely on from July 2008 to July 2018 for 10 years her legal stay in this country, that means that 121 days she was out of the country in December 2007 till April 2008, that will go out of the list which the Home Office was relying on. And that means that if you take 121 days out of 646 days, that comes under 540 days. So that was the argument which I thought I can rely on using Home Office own record. I wasn't relying on my own evidence. I was actually relying on their record which they provided, same record which they were basing their refusal. So I was satisfied with that. I might have something here which might help us. So the very first thing what I did at the appeal hearing is to speak to the Home Office representative just to confirm which list she is relying on, whether it's 701 or 646. Because if it was 701, even though 121 you take out, you still more than 540. But she confirmed that yes, 646, she will be relying on that figure. And then I said to her, on that basis we will go to the court on agreed figure. And she asked me, what is agreed figure? I said 646. And she said, but you still out more than 540 days, you still will lose your argument. And I said to her, we will see in court, then we'll see how the judge will interpret that. So we went into the court, and very first point I made to the judge is that we have agreed dates. We have agreed that there is no dispute on the dates, that how many days she was out of the country. We have come to agreement that 646 days she was out of the country according to the Home Office, and we accept that. And at that point, even judge pointed out, then what is your case? You're supposed to be less than 540 or maximum 540, but you're accepting that your client is 646 days out of the country in the last 10 years. Then what is your argument? And that's where I came with this argument to the judge, that if I'm not relying on from July 2007 to July 2017 at the time when we made an application. I am relying today from 2008 to 2018 of my legal stay in this country. As a result of that, if I do that, I will take out 121 days out of which she was out of the country in 2007. So therefore, I am under 540 days. Now, why I say if I'm under 540 days, because last year from July 2017 to July 2018 she never traveled out of the country. The reason being her passports were with the Home Office, because when they refused her application they kept her passports. So admittedly she was not out of the country a single day. So from July 2008 to July 2018 she was here legally 10 years, less than 540 days. Therefore that is my point. And on that basis the judge asked the Home Office what she have to say on that. And the very first thing, I can see her shocked. She was very shocked because she couldn't see this coming. She came up with all this information to basically undermine our case. Now what we did is use the same information to basically have a point which judge even was agreed, because our client has by law choice which of the 10 years she can use, the last 10 years or first 10 years, and we choose last 10 years. Now one thing she said, oh, she could have gone out of the country last year, which we don't have record here, and the judge said you can, it is very easy to prove. The client is here, the applicant, you can ask her. And secondly, how can she travel out of the country when you have her passport? Or even if she might have gone out of the country, how would she come back to the country? So on that point obviously Home Office didn't have any argument to make, and then the judge helped her to say don't take any position, don't consent to this, but say you are not taking any position on this and I will make a decision. And that's what actually she did. So then the judge turned around to my client and said, thank you very much for coming in. There won't be any question from us or from your own solicitor. I'm instructed not to make a decision on the same day. What I normally do is go back, look at the files and then make a decision in writing. But I can tell you that your appeal will be successful, and the Home Office, I'm not giving you indefinite stay, but the Home Office will give you, because your appeal is successful. Needless to say that my client was so happy when she heard those words. The point I'm making, and the reason I'm sharing this case, is that the few things. First, that if your application is pending with the Home Office or your appeal is pending, your stay is legal. If you're basing your long-term application, long residence application, you have a choice to use which 10 years you want, but those 10 years have to be continuous. Either you can take first 10 years or last 10 years. Then you can see that if this situation you are facing, like more than 540 days, which I believe most of the students have this problem. The reason being, if you calculate 18 months out of 10 years that you can be out of this country, that means roughly about 7 weeks a year. Now if you are in a private school, you have more holiday than on a state school. Now, even if you're in a state school, basically 6 weeks summer holidays, then you have a midterm, then you have an Easter break. All of this comes to the more than 7 weeks a year. So if you're a very young age coming here and maybe staying in a boarding without your parents, the very first thing you do is to, as soon as you get holiday, you go back home, spend time with your family. So you are most likely will be out of the country more than 540 days out of 10 years. So the information which I shared with you, that will help you. The whole point of sharing the facts of this case and the outcome is that may help someone who is going through the appeal process, which might have a similar circumstances of facts like I shared with you on this case. That will help them. And the whole point of me preparing these videos is to help others. If someone, One thing I will always say is that if you are not sure, and if you are making this based on long-term residence application here, please always take advice. Please always get to your local solicitors, immigration advisor. They can advise you on these minor points, and as a result of that information or advice, you will have your chances of success are even greater when you make an application without that advice. So good luck with your applications, any future application you're making, or if you're going to the appeal. I will be making more videos on different cases. Point is just how can I be more helpful the individual you're going through the immigration process, which I believe, and from my experience I can tell, is very stressful. It's very, very stressful the time for the individuals involved. Thank you very much. Have a lovely day, and thank you very much for watching this. Thank you.